Procedural safeguards and due process. Due process is the regular administration of the law, according to which no citizen may be denied his or her legal rights, and all laws must conform to fundamental accepted legal principles. Procedural safeguards are requirements set out in the Individuals with Disabilities Education Act that provides guarantees for parents and their child with disabilities. It also provides both schools and parents with guidelines for resolving any disagreements. Due process procedures are the rights and procedural safeguards given to parents and their children or students with disabilities under state and federal law. IDEA requires that the parents of children or students with disabilities be given the opportunity to participate in all aspects of developing, planning, acquiring, and implementing special education and related services specific to their child. In cases where there are no parents or guardians with legal rights over the child or student, the district where the student resides has an obligation to ensure that someone is appointed to represent the child or student in accordance with state and federal law. Under the Individuals with Disabilities Education Act, it is required that a copy of the procedural safeguards be given to the parents of a child with a disability at least one time in any given school year. This includes the first time a child is referred for a special education evaluation, the first time a parent files a complaint with MDE in a school year, the first time a parent or the district requests a due process hearing in a school year, the date the district decides to change the placement of a student by removing the student from school for a discipline violation, or at any time upon the request of a parent. Parents are advised to read and understand this document to understand the effects. The procedural safeguards document also stipulates time within which notification of consent or lack of consent should be returned, as well as what it means if neither is received. This document provides parents with a list of people to contact in the event that clarifications, translations, or more information are required. In the event of disagreement between parents and districts regarding identification, evaluation, placement, or provision of free, appropriate public education, parties are encouraged to seek resolution through various means, such as conciliation, mediation, facilitated team meetings, or other alternative processes. The special education complaint process is an available alternative process for resolving disputes. Stipulations on how to initiate the complaint process, as well as the process it follows, are detailed within the procedural safeguards document. A couple of the rights and guarantees inherent in IDEA and that are outlined in this document include parent access to student records and rights to ask for records to be amended, parent rights to participate in discussions that led to decision-making pertaining to their child's education, and more. In 1975, when Congress enacted the Education for All Handicapped Children's Act, now IDEA, they included procedural safeguards in order to protect the rights of children with disabilities and their parents. Due process procedural safeguards are created by each individual state and implemented under Public Law 94-142, IDEA. Procedural safeguards are provided to parents under IDEA and provide parents a description of their rights. Each state educational agency must ensure that each public agency establishes, maintains, and implements procedural safeguards. Procedural safeguards protect parents of children with disabilities ages 3 to 21. In the case our group reviewed, a student was diagnosed at an early age with ADHD and became eligible for and began special education during the 2nd grade. During his 8th grade year, he was placed by his parents in a private residential school specializing in educating students with nonverbal learning disabilities. After that year, he returned to Minnesota and attended Southwest High School, located within the district. He attended school within the district in his 9th and 10th grade years, where he received special education services. The parents did not feel that he was making adequate progress, secured insurance authorization for private placement, and moved the student to a private school without providing notice to the district prior to removing the student. A complaint was filed by the student's parents indicating that the district had not properly evaluated the student and identifying his needs. The parents wanted the district to develop a plan to transition the student back to an effective district educational program and receive reimbursement for the cost of the private school residential placement. The parents had not properly notified the school when moving the student, so the district denied liability. The administrative law judge determined the district was not liable and denied compensation. The parents and district have since been required to come to an agreement that will enable the student to complete education and graduate. Procedural safeguards contain many implications for school districts. Here are 4 of the most important school district implications for districts that school staff should be aware of. The first and most important implication is that the district must provide parents with their parental rights under the IDEA at least once a year. This is generally done at the beginning of the school year or at each IEP meeting. The copy of the parental rights should be provided in the parent's native language unless this is an obvious, unreasonable requirement, meaning the district has no resources to translate the parental rights into the parent's native language. A copy of the parental rights must also be provided to the parents by the school district at the following times: when a child is first evaluated for special ed services, the first time the parents file a complaint in that school year, the first time the parents or district request a due process hearing in that school year, on the date the district decides to change the placement of the student by removing the student from school for a violation of the district discipline policy, and upon parent request. The second implication for school districts is providing the parents with a prior written notice. This is provided in order for the district to obtain consent from parents before an initial evaluation, initial placement, and provision of special education services and related services, reevaluations, and receipt of transition services. Districts cannot override parent refusal or lack of consent in these areas. In other areas of special education services, such as a new IEP, the district can put their proposal into effect if the parents have not responded within 14 days of receipt of the PWN. If the parent objects to a district's proposal or refuses the PWN, the district will ask the parent to attend a conciliation conference. Within 5 days after the final conciliation conference, the district must prepare and provide the parents with a conciliation conference memorandum that describes the district's final proposed offer of services. If there continue to be disagreements amongst the district and parents, the district or parents can use mediation, a facilitated IEP team meeting, or request a due process hearing. The third implication for districts is to maintain confidentiality of personally identifiable information of its students. Written parent consent is required before a district can disclose personally identifiable information about the student with anyone other than officials of participating agencies collecting or using the information under the IDEA. Districts must also give parents the option to refuse to let the district designate any or all data about their child as directory information. School districts must also protect the privacy of student records. Written consent from parents is required for anyone outside the school district or the parents to access the information in the student's educational records. The fourth implication is that districts can bill for health-related services if the student is insured under medical assistance or Minnesota Care. The services are billed as personal care assistance services as provided by paraprofessionals or educational assistants. The district must inform the parents in writing that the district will share data related to the student and health-related services on the student's IEP with the Minnesota Department of Human Services to determine if the student is covered by MA or Minnesota Care and if the services can be billed. The district must obtain parental consent in writing before beginning to bill for health-related services the first time. There are many resources available to aid parents with procedural safeguards that are provided by the state of Minnesota in school districts. Parents of children or students with disabilities must be provided the opportunity to be involved in all aspects of developing, planning, acquiring, and implementing special education and related services specific to their child. This is Minnesota state law. The Minnesota Department of Education provides parents and districts information for all laws and policies regarding procedural safeguards as required by the state. Minnesota state law does require counsel to accompany and advise parents with respect to the problems of children with disabilities. ARC Minnesota is a private, non-profit, statewide voluntary organization with the mission of promoting and protecting the human rights of people with intellectual and developmental disabilities and actively supporting their full inclusion and participation in the community throughout their lifetimes. They provide crucial information for people with DD and their families, connect them with resources, and stand with them when they need an advocate. The ARC and its services are available to all citizens of Minnesota at the local and at the state level. The Minnesota Association for Children's Mental Health has a mission to promote positive mental health for all infants, children, adolescents, and their families. Their aim is to educate the public to remove the stigma and barriers associated with children's mental health disorders. They also serve to educate families about multiple systems that serve children with these disorders and help to navigate these complex systems. They serve as an advocate for services that meet unique needs of parents from culturally specific communities. The Minnesota Disability Law Center is the designated protection and advocacy system for Minnesota and addresses the unique legal needs of Minnesotans with disabilities. MDLC provides free civil legal assistance to individuals with disabilities statewide on legal issues related to their disabilities. All individuals with disabilities are eligible to receive help, regardless of age or income level. The Minnesota Brain Injury Association is a statewide nonprofit, and it is dedicated to enhancing the quality of life for Minnesotans affected by brain injury. This alliance has developed from an advocacy-driven organization to one that focuses on both advocacy and direct service. They serve people throughout our state of Minnesota, and for parents, this organization does provide resource facilitation services, which provide personal one-on-one connection to information and resources. While the Parent Advocacy Coalition for Educational Rights is a national organization, on their website there's a page called the Minnesota Parent Center, MNPIRC. It's a project of the Pacer Center, and it's a statewide project designed to help families and schools build stronger ties to benefit students. They make themselves available to answer questions and help solve school-related problems, which can come in the form of legal advice.